Today's date is June the 12th of 2025. It's 10 o'clock a.m. and I'm going to call this regular meeting of the State Ethics Commission to order. The first thing I want to address is the agenda for this meeting. It looks like the agenda is in 10 parts. Have all commissioners and staff had an opportunity to review that agenda? Not hearing anything. So are there any changes as presented from the staff?
Yes. Under preliminary hearings, position C, matter Chelsea Thompson, that is a consent now.
All right, we're going to move that on the agenda to item N under consent orders.
And then in position D, under preliminary hearings, the matter Joseph Mark. Does that matter? There was a preliminary hearing waiver signed by both the respondent and his attorney.
Okay.
And that's to each of the allegations that were put forth in the complaint.
So I'm still going to call that case then, and so that you can put into the record exactly what the status of that particular case is in. I did notice that at our last regular meeting, there was case number 24-0083C. It was in the matter of Atlanta DCA Limited. It was continued as from the preliminary hearing calendar on the last meeting. What's the status of that case?
We had subpoenaed records from one of the vendors for that related to that investigation. And we've now finally got confirmation they're going to respond to the subpoena. We're waiting on additional evidence. I would anticipate being able to present that at the September meeting because we just didn't get the records yet.
It's anticipated that'll be on the preliminary hearing portion of the calendar?
At this point, yes.
Okay. Any other changes to the agenda?
Yes, under consent orders, position G, in the matter of Justin Hawkins, we'd ask to continue that to the September meeting. That appears like it should be a consent. It's just a matter of being able to connect with Mr. Hawkins' attorney.
So that was my next question. So Mr. Hawkins is represented?
Yes, sir.
Okay. And there's been agreement on his part to continue it until the next meeting?
Well, there is
probably getting a response from the attorney. Yes.
There's been conversations back and forth. We have to, I think in principle, we have an agreement in place. We just need to have the final conversation to get this.
All right. So item G under consent orders would be removed?
Yes.
Any other changes to the agenda?
No, sir.
I'll go ahead and make a motion to approve the agenda as amended by the staff. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Hearing none, motion carries. Item 2 on the agenda is going to be review and approval of the regular commission meeting minutes from that last meeting from March 24th, 2025. Have all the commissioners had an opportunity to review those minutes? Are there any changes as presented with respect to the minutes, whether it be from a commissioner or from staff? Hearing none, I'll go ahead and make a motion to adopt those meeting minutes as presented. Do I have a second? Second. Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Hearing none, that motion carries. We're going to go ahead and move to item number 3 on the agenda. Those are the preliminary hearings. We're only going to proceed then, if I'm understanding today, with items A and B. So I'm going to go ahead for A and call the case of 24-0098-C in the matter of Nicole. Is it Messiah?
It is.
And Ms. Messiah, you're here for that?
I am, yes, sir.
And Mr. Knittel, you're going to be presenting the case on behalf of the staff?
Yes, sir.
Okay. We're going to let the staff present the case first. You certainly have an opportunity to object to any evidence that he submits or anything of that nature. And then we'll hear your side of the case when the staff is concluded.
Sir.
Okay. Mr. Knittel.
Thank you. This is the matter of Nicole Messiah, case 24-0098-C. Excuse me. By way of background, Ms. Messiah was in the special election for the DeKalb County Commissioner, District 3, which was held back on November 5th last year. She advanced from that special election to the runoff and was successful in her runoff election. She did file a DOI back in May of 2023, and she qualified between April 1st and April 5th, 2004.
Make sure you speak up enough. Are we getting them audio wise?
Yes. So I will speak up. The procedural history in this, the original complaint was a third-party complaint that it was filed within our office from Mr. Travis. Back in September 9th of 2024, there was an amended complaint and a second amended complaint filed February 17th, 2025.
The amended complaint and the second amended complaint, those were both filed by the commission staff, right?
Yes, that is correct.
Okay.
And the respondent confirmed she had received the original complaint. There was some initial contact by Ms. Messiah to our office back on October 30th was the first initial contact that I have record of. Then again in November 2024. During that time, the initial complaint started off related to not filing a PFDS in time. I had discussions with Ms. Messiah back before the December meeting related to a possible consent related to the missing the PFDS filing. That was not completed in December. And at a point before the runoff election, the special runoff election, in one of the emails I sent to her, I indicated to her, please be advised or something to that effect, that there will be a special, there's a runoff, a 6-day report due before the runoff election. So after that, sometime, I think it may have been in late January, early February, I was reviewing the races that took place in this particular candidacy, and the runoff report for the special election had not been filed, nor was it December 31st, 2024 CCDR report filed. So those simply weren't filed. So basically you're missing 2 CCDRs and the PFDS. Ms. Messiah did file the PFDS, albeit it was after the original complaint came in. So we treat that as not filed because it wasn't filed prior to the complaint being done. So it's not just a late PFDS.
All right, I've got a couple of questions. I don't want to get ahead of you necessarily, but I've been looking at the amended complaint and then the second amended complaint. As I understand the second amended complaint, it alleges that the respondent failed to file the 6 days before the special election runoff campaign contribution disclosure report.
Yes.
And then that she failed to file the December 31st, 2024 campaign contribution disclosure report.
Yes.
And the third allegation is that she failed to file that 2024 personal financial disclosure statement.
That's correct.
Right. I'm just curious, in the original amended complaint, and I don't know if you have access to that at the moment.
I can, but I might remember what.
Okay. Under paragraph 9, there were 5 different allegations. And I didn't see those, and I could be wrong on this. I didn't see those to be carried over into the second amended complaint. It looked like those allegations were different. So what happened to those 5 allegations under paragraph 9 that were in the original amended complaint?
Yes, and that's a very valid question. I can explain that. When the original complaint came in, the third-party complaint, did not realize that this was in a special election. It wasn't until after the amended complaint was filed and I had contact with the respondent, I realized this was a special election. It was a kind of a unique situation. The special election was falling on the same day as our general election. And so that was simply an error. That's why the second amended complaint was filed without those allegations.
Okay. Thank you.
So, yes, sir, Mr. Vice Chair.
So what reports were filed? What reports were filed?
So and now this I don't have in front of me, but I believe Ms. Messiah did file several of what would be the normal calendar year CCDRs.
But this is a special election, right?
Correct.
So there's a 15-day before.
Yes.
And she filed that 15-day before.
She filed a report in October, the October 25th report. And in my discussions with her, I let that be treated as the 15-day prior report. It was very close in time to the 15 days.
So the answer is she did not file a 15-day, but she did file on October 25th.
Yes,
And
that's correct.
you are accepting that as a 15-day before.
Yes, I did, based upon my conversation.
Okay. But I'm not trying to, it's our job to enforce the law, not change the law.
I understand that.
Okay.
I guess I took into account, and I respect what Vice Chair is saying. I took into account that she actually had filed previously reports that she didn't need to file. She had actually overfiled up to that point.
So the October 25th report that she did file covered through October 25th. What would the 15-day report cover? Would have been earlier than 25th. So you're saying that she disclosed more information she needed to.
Yes,
Now, with that said, once you file a special election report, you start on the 2 business day reports, having to file those.
yes.
Were there any contributions over $1,000, and were there 2 business day reports filed at that time?
I do not recall there were any 2 business day reports filed. I also do not recall right now if there were any contributions that would have met that threshold.
Okay, so we don't know.
I do not know.
And again, the only thing that's being alleged and the only thing that we should take into consideration right now for purposes of this preliminary hearing are the 3 allegations that are set forth in the second amended complaint.
Yes,
Those are the only 3 that we can consider because those are the only 3 that she's been provided notice about.
yes. There was a subpoena issued in February with the March return date as it related to the additional allegations in the second amendment complaint, and did not receive any response. That would be for financial records and such for the candidate. Excuse me, Mr. Yeah, are you able to remove that little window on there?
Yes, yes, sorry.
Thank you. This is simply the statute, just for the record here, that 21-550 indicates when a personal financial disclosure report shall be filed. That needs to be filed with the commission no later than the 15th day after qualification. That's under OCGA 21-550. Ms. Messiah qualified during the first week of April for this special election. There was, and therefore the PFDS would have been due 15 days after April 5th. This was when the personal financial disclosure report was filed. It would have been October 11th. It's a little far for me to see, but it's October 11th. And I indicated it as a pop out there. The third party complaint came in on September 6th. So that's why it's being treated as not having been filed. But I do want to indicate she has in fact filed it at this point. And so that's one of the violations, failure to file the PFDS covering 2023. So the special election filing requirements, they're under 21-534C4.
I'm sorry, Mr. Kennedy, I got to stop you again.
Yes, sir.
Again, I'm looking at the second amended complaint, and it says that she failed to file the 2024.
It covers the 23 calendar.
Covers 2023 calendar.
All right, sorry, go ahead.
So in any event, this is the statute that indicates when the CCDRs are required to be filed for special elections, the 15 days prior to special, and then I underlined 16 days prior to the special election runoff. And this is the rule that also supplements that, as provided, candidates in a special election must also file December 31st CCDR. That's just showing that when she did file her DOI, and she had a RC filed back in 2023. These are the CCDRs that have been filed by Ms. Messiah. The last one being the October 25th CCDR report that we previously discussed, was filed on November 1st, 2024.
Wait, what
Yes, sir.
What is the one, go back one? What is the NA June 2023 that was filed on 2/9? Is that the 131?
So I believe that was filed, that was a June 2023 report. She had filed her DOI, go back here,
Yeah.
back in May. So I believe that report was related to it. That's just a copy of the most recent CCDR. I'm not able to, I guess, zoom in on this, but that's the net balance that was on hand as reported by Ms. Messiah back in their most recent filing. I think this is approximately $36,000 net balance. She advanced in her election to the December 3rd special election runoff. And so the violations as it relates to CCDRs were what we discussed already: failure to file the the special election runoff 6 days prior, and also the December 31st, 2024 CCDR. And so there's reasonable grounds to believe that respondent violated Campaign Finance Act in those three manners that we discussed for failing to file the PMBS and the 2 CCDRs.
I appreciate that one because it tells me that the 2024 covers the 2023 calendar year.
And that's always a confusing thing because it's filed a year, but it's covering the previous year. So that's why I try to be flexible with that.
All right, now I'm going down the road to ask a dumb question, I'm sure. I want to go back to this subpoena.
Yes.
And again, to whom was the subpoena sent?
To the respondent and the commission.
Okay. And by virtue of there having been no response to the subpoena, how does that impact the commission's case?
Well, I'm just indicating I don't have any ability to look at any expenditures or contributions to, to compare them to any CCDRs. There are not, so I can't indicate if they were, for example, hypothetically, if there were expenditures made that were not disclosed, I'm not able to put those as independent allegations.
This is a matter that the two of us have disagreed about over the course of a number of meetings. Here's what I want to establish. If you get a response to that subpoena and you get further evidence showing additional violations, we're not prejudiced from pursuing those since they are not part of this particular case. So even if we find, that there are reasonable grounds to believe that these three violations occurred, we can still bring those additional matters against the respondent in the event that if we were to get a response to that subpoena, that it shows that there were further violations.
Yes, I completely agree with what the chair said.
There's no issue of jeopardy attaching for separate violations.
Jeopardy is the word that I was looking for as opposed to prejudice. Yes.
This may be a question for Mr. Amati. That is not my phone. Thank you. I turned it off. What is the procedure for when a subpoena is not answered? I guess my question is to the chairman's point, we can go back and take it up, but now we're just rehashing and doing more and all that other stuff. Why is this case even before us? If the subpoena, what's the next step for the subpoena? Or we just quit if they don't respond?
So here's the issue. If the subpoena is ignored, we don't move forward with something, then the case dies. We can't let that happen. Now,
Because of statute of limitations?
No, just because if you're saying we never move forward without an answer to the subpoena, if we never get an answer from the bank or the respondent, then how can we ever move forward?
But
So to answer your question, in a case where we don't get an answer to the subpoena, we move forward with preliminary hearing. We move, presumably, we find probable cause, move to OSA, where we have a judge who can hold in contempt failure to turn over the bank records. And then when we get those bank records at OSA, we have to make a decision. Are there additional allegations? And if so, are they of the substance that we need to wind it back, amend the complaint, bring it back to the board, or does the punishment fit, the offense, so to speak, already?
so I'm sure the answer is you don't know. So the bank was not subpoenaed because you don't.
We don't know who the bank is. Yeah.
We filed, in Superior Court to get folks to, respond to subpoenas, right, Michelle?
That's correct.
That would also be,
There are a variety of ways that you can approach a subpoena issue like this, depending on what the facts and circumstances are. Sometimes when we take the cases to OSA, and a subpoena has been issued kind of as a matter of form, but we don't really feel like there's a case to be found. We use that as evidence in the penalty case. And I feel like administrative law judges tend to view that as non-compliance and award a higher level of penalty than in a case where you don't have that kind of behavior. But if we have facts that, make the commission question what's going on with these underlying funds, you can either address it with the ALJ as part of the OSA proceeding, or you can take it to Superior Court, which, when it comes to, levying civil contempt sanctions and things like that is kind of really where you want to be in a serious case. So we work with staff counsel on on a variety of these approaches, and we've had them go directly to Superior Court, and we've also dealt with them at the OSA level. Kind of depends on what we think we might be looking for.
And Ms. Young, correct me if I'm wrong, but the instances where we have filed a motion to enforce the subpoena in Superior Court, I believe those have only been in cases where we did know what particular bank was in question. We had subpoenaed it, and the respondent had objected under that statute to those records being released.
Well, that was definitely some of our more major cases.
Yeah.
We have had other cases with y'all where we have taken subpoenas that weren't for bank through as well.
Yeah.
And are happy to do that whenever the commission feels like that's the route that we need to go to get information to build a case before it goes to OSA, or to take a case to OSA. That's how you want to do it in those types of circumstances. Here, it seems like you've got a case that you have some violations that are ready to go. So it's kind of a judgment call of whether, and we can talk with staff counsel about those options as we prepare the case. But there are kind of different tracks that you can, pursue for subpoenaing documents. We can subpoena documents to be brought to the OSA hearing for the purposes of the failure to file charges as well. So
Mr. Knittel, you issued a subpoena. Is that true?
Yes.
Was there any follow-up after the subpoena?
No, sir. And I would like to, so when the First Amendment complaint went out, there was a subpoena issued in that.
Okay,
So there were two subpoenas. However, in that particular case, if you recall, ultimately it appeared it was only going to be dealing with the personnel financial disclosure statement not being filed. In a conversation I had with Ms. Messiah, it was because of special election.
but were you subpoenaed?
Well, I initially thought it was in a general election and that we were missing report CCDRs at that point.
Okay.
And so in a conversation, I said, you don't need to respond to that subpoena because we weren't talking about CCDRs at that point. Then the Second Amendment. Are you tracking with me?
I'm hearing you.
Then the Second Amendment complaint went out where there were actual CCDR failure to files. So the second subpoena went out specifically at that point. That's the subpoena there was no response to.
So, and this is, the chairman can explain this to me if he wants to, but with the certificate of service, it appears that we just put it in the to a post office box. So how do we know the post office ever delivered it? Is there a standard for certificate of service?
Well, we have, I believe we get notifications back. I have to look in this particular file to answer your direct question.
We get verifications that it was delivered to the address that the individual provided to the commission.
To the PO box?
That is the standard.
Okay.
If they provide us an address and we can verify it's delivered.
So this is certified.
Yes.
Okay. Thank you.
I think Mr. Yap wishes I would spend less money on certified mail, but we tend to only use certified mail.
Okay.
Anything further, Mr. Knittel?
No, sir.
Ms. Messiah?
Yes, sir. Thank you.
I guess my first question before you start your presentation is, why didn't you respond to the subpoena?
I don't get a subpoena, Your Honor. Sir, I'm sorry. I never got a subpoena. What I got was an email, even as it relates to being here today. I received an email, I want to say it was a week and a half ago from Mr. Mattel's office. And then I received this last week as well with the notice to be here. It was on my floor, like on the ground by my trash. So I've never received a subpoena, Your Honor.
Okay, but before, again, I'm not trying to cut you off.
Yes, sir.
Mr. Knittel, what proof do we have of service for this case? It's in the binder.
According to Ms. Easterwood, she will be able to find this page faster.
Well, page 14, there's certificate of service, but I don't see
Page 56 for the amended
56.
UPS confirmation that they send back to us.
Which one? It's
56.
yeah, I know. What does that show delivery of?
It's not going to give specifically complaint subpoena. It just shows delivery of the package that was sent.
Read. What date is it?
Shipped on 2/17, delivered 2/19.
So again, I want to make sure we got this right. In the what was actually shipped to her on 2/17?
It don't say.
Well, can we go back and look at the letters that we have or whatnot to see what it was that we sent them?
217 was the second amended complaint and the subpoena.
And with the subpoena with it?
Yes.
All right, this shows proof of delivery. Does it have an, and I apologize that I can't, does it reflect an address?
Number 2. And it's just some photo.
I saw some of those photos in there. I mean, to me, those are the two most important documents that would have been sent, the second amended complaint with the subpoena.
And I've gotten neither of those. Like I said, this is what I got reference to the hearing. I got it emailed by Ms. Eastwood to come, and I got this a couple of days after, and this was in there. That's just all I had.
See.
And where were those delivered?
It was delivered to my house and it was on the ground.
What's the
My
address?
trash, 2353 Rover Court, Atlanta, 30317.
Yeah, we've got a
6/3. But it's me. That's not the subpoena.
If it makes Mr. Nattel unhappy, I have a copy of all of my bank statements. I have them with me today.
Mr. Canetto, do you have
Sorry.
a picture of the delivery of the subpoena? I see the one for the notice of hearing.
No, we do not have that.
The subpoena is not even necessarily the big thing to me now that I'm looking at all this, because the subpoena is only going to relate. We don't need the subpoena for there to be the 3 violations
Right.
that we've talked about today.
Correct.
Those are violations without the subpoena.
Correct. Subpoena is just to
Yeah.
get everything.
The cart's sort of getting before the horse. The violations are the reports we're not finding.
I know, right. Tell you what, I'm going to recommend. If, Ms. Messiah,
Yes, sir.
if you could, Mr. Knittel, what do you have? Do you have the next
I have the next one.
prelim?
I do.
Before I even suggest that this matter be continued, we're gonna, I guess, table this case for right now. I'm gonna give you guys an opportunity to talk, figure things out, and see if y'all can't get it resolved since she's here.
Okay.
And then, we may we will come back to it either way. I want you to think about whether you feel like, there needs or need not be a continuance of this, just to make sure that we don't have any issue regarding service.
Okay, we'll do.
Is that all right?
Yes.
Is that okay with you, Ms. Messiah?
Yes, it is. I'll just add, obviously driving an hour and a half from Atlanta. This started with an opponent in the case who's actually here today filming right now. Opponent in the case who filed against the two women in the case, feeling as though it would give him an edge. And so he utilized the information. I sent this to Mr. Knittle's office. He literally kept sending that I'm under investigation, not, of course, sharing that he filed a complaint. The original complaint that he filed had all these allegations that were obviously incorrect, which is why I guess there's an amended, but I'd like a copy of that amended as well, because I have not gotten any amended complaint either.
That's why I'm suggesting what I'm suggesting.
But again, the core issue is failure to file the PDF and the campaign disclosure in a timely fashion. And the subpoena is not as important to me as the failure to file. And I understand what happens in a political campaign,
Yes, sir.
but the code is what the code is. So
And I completely understand.
Again,
With the
I agree with you.
campaign committee and special election. But again, my understanding is that they were filing as they had filed the other ones, notwithstanding whatever the commission thinks is best. Happy to, meet with Mr. Knittle. I have all the bank statements, my Act Blue statements printed out. There's absolutely nothing to hide or to, in this case, again, it's just political rhetoric. And my understanding is Mr. Travis consistently called
we've got a system set up where a citizen can file a third-party complaint.
Yes, sir.
And, I understand what you're saying, and, you can argue that there was no merit to what was filed.
Mhm.
What's before us today are 3 allegations.
Yes, sir.
Those are the 3 allegations that I'm taking into consideration.
Yes, sir.
So whatever is happening behind the scenes with regard to, Mr. Travis, to me, that's irrelevant to why we're here today.
Fair enough.
And I'm going to give you the opportunity
Yes, sir.
to talk to Mr. Knittle to see if y'all can come to some type of resolution to this. So I'm going to make a motion to table this case 24-0098-C only temporarily during the term of the present meeting. Do I have a second? Second. I got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. Any opposed? All right.
but as we go forward, that we probably need to be considerate of her time, and that it may not want to be tabled until fall meeting, another one out of the Atlanta area.
No, that's why I said that motion was only for tabling it as of right now during the present meeting. And then we will come back and address it. All right, Ms. Messiah, what I'll tell you on that is Mr. Knittle's got some other business that he has to address.
Yes, sir.
And whenever we have a break or whatnot, I'm going to give you all the opportunity to talk. Okay.
Yes, sir. Thank
All right.
you.
Thank you very much. All right, we've got one more preliminary hearing today, and that's item B under preliminary hearings is case number 25-0015-C in the matter of Jacqueline Walls. Ready to proceed on that one?
Yes.
Is there anyone else present in this case? Okay, Mr. Knittle, go ahead.
In this case, Jacqueline Walls, 25-0015C. This is actually related to the same election that we were just talking about, just a different candidate. Ms. Walls was also in the special election that was held on November 5th, 2024 for District 3 DeKalb County Commissioner. She filed her DOI in February 24, filed campaign committee in March, and also a CUSA. She qualified between April 1st and April 5th, just like all the other candidates which were in that election. She was unsuccessful in her election, did not advance to the special election runoff. The procedural history on this particular case, commission staff filed a complaint on February 20th, 2025 this year. A subpoena was issued with the return date of March 20th. Our office did not receive any records. Commission, we alleged 2 CCDRs failure to file. There's been no response by the respondent. In this particular case, I just want to bring this to the attention of the commissioners. In our December meeting, 2024, there was a consent with Ms. Walls related to her PFDS. She had missed her personal financial disclosure statement filing. And at the point of that meeting, she had not, we were not to the point where she would have had to file CCDR. So there was a consent done on the PFDS. Like I stated in the earlier case, in this particular election, I went and looked at the election reports that were filed, CCDRs, and I also observed that Ms. Walls had not followed up and filed the required reports that she needed to file in her particular case. As I stated before, candidate in a special election or special election runoff, a special election requires 15 days prior to a special election, 6 days prior to a special election runoff. And also there's a requirement to file a December 31st CCDR 189-3-.01. In this particular matter, there were no CCDRs filed by Ms. Walls. So she has everything else filed here, registration, her PFDS, which she filed after the original complaint went out, and then nothing since then. This is just to show that there certainly was money spent on this, and I understand this wouldn't even matter. She'd be required to file the CCDRs, but I do want to point out that we did do some investigation to see was money even spent in this campaign, and how much I have no idea, but there was certainly money that was expended by this candidate. And so this is really, I think, a rather straightforward case. There's reasonable grounds that she violated the act by failing to file the special election CCDR 15 days prior, and also failure to file her December 31st, 2024 CCDR. That is a very straightforward case. I did not receive any records on the subpoena on this. We sent everything certified mails we're supposed to, and I believe, UPS, excuse me, UPS. And did we get confirmation of those? We did.
Okay. Anyone here on behalf of the respondents in this case? Hearing none, I'll go ahead and make a motion. Make a motion that reasonable grounds exist to find that the respondents violated the Campaign Finance Act by failing to file the CCDR 15 days prior to the special election in violation of OCGA 21-5-34C4 as alleged by the commission staff. Do I have a second?
Okay.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion carries. I'll make a motion that reasonable grounds exist to find that the respondents violated the Campaign Finance Act by failing to file the December 31st, 2024 election year CCDR in violation of OCGA 21-5-34I2 and the Georgia Comp Regulations 189-3-01.018. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right, that motion carries. That takes care of that case. And that's the end of the preliminary hearings for right now, correct?
Yes.
All right. We, Mr. Canino, it looks like we're going to move to item 4 on the agenda, but it looks like under the consent orders, your cases are first, Mr. Baywall's cases are second, correct?
Yes, that's correct.
Who's got, Mr. Baywall, you have the Chelsea Thompson case that's been moved down here?
Yes, sir.
All right. Mr. Canino, we're going to do yours first. We'll get through those, and that way you'll have time to go back there and meet with Ms. Messiah. Is that okay?
Thank you. I appreciate that.
Okay. I'm going to call case number 24-0064-C in the matter of Clarence and Glenn Cook. Mr. Canetto.
Thank you. In this case, it's 24-0064-C.
Oh, hold on. Sorry. Back up. I apologize before we get to that. We need to address this Item D under the preliminary hearings. Sorry about that. I forgot as well. Sorry about that. I'm going to go ahead and call case, and again, we're back under the preliminary hearings. I'm going to call case number 24-0086-C. That's in the matter of Joseph Mark. I understand that there will not be a preliminary hearing, Mr. Baywall, is that right?
That's correct.
And explain to us why that's the case.
And Mr. Commissioner, I'm flying by the seat of my pants on this waiver of a prelim and stipulation of reasonable grounds. But essentially, I talked with Mr. Knittel. Mr. Knittel previously was in my position a couple board meetings ago, and he had talked to Mr. Lane about this process. So I'm not exactly sure procedurally all the information that you're looking for here, but what I can tell you is this complaint originated back in August of 2024. I did have contact with Mr. Mark. He provided me his financial information. There was the original complaint had 6 total violations. He provided his financial records. I got back to him in October or early November of 2024. And he had some cleaning up to do with his filings. He had one filing that amendments were needed because contributions and expenditures were not reported. And he had 2 other filings where he hadn't filed anything at all. And because of that, all contributions and expenditures from those periods were not reported. This was a case that was originally docketed for our December 2024 board meeting. And prior to the board meeting, Mr. Mark contacted me. He said he was going through some medical issues, and also knowing that he had some work to clean up with his filings. And he only had a few weeks before that board meeting to fix it. He hadn't fixed it. I moved the case to the March calendar. When we got to the March calendar, again, he was instructed on cleaning up his filings, and I did give him some direction with what his numbers should look like. He had a little bit of legwork to do, but I tried to steer him as much as I can, saying, hey, this is kind of what the amendment should look like. This is what the 2 missed filings should look like. We were trying to get those filings completed before the March board meeting. He didn't get them completed before the March board meeting. In addition to that, Mr. Mark does have counsel for this matter representing him. We didn't have a fully executed consent agreement in March, so we passed this off to the June calendar. Mr. Chairman, you specifically said that if this case isn't resolved by a consent agreement, it's going to go to a preliminary hearing. After the March board meeting, I got back on the phone with the attorney and Mr. Mark, and we reached the consent agreement. And based on the procedural history, what I said needed to happen: number 1, the filings need to be completed. Number 2, you need to start making payments on your penalties as of May 1st, 2025. I thought my directions were pretty clear, but as we were preparing the docket for this June board meeting, I checked with Gwinnett County and their Board of Elections to see if the filings had been done. They had not. I checked in her office to see whether Mr. Mark made that May 1st payment. He had not. Got back on the horn with didn't get into contact with Mr. Mark, but got into contact with his attorney. Again, his attorney had said there are some medical issues going on with Mr. Mark. They did provide some documentation of appointments. Mr. Mark is also a veteran, and I know the VA is involved. He is either medically disabled right now, or he's in the process of trying to get a medical disability. Where we are today, this is a case that Mr. Mans has expressed to me. They're not contesting the violations. This is something that they want to work out with the consent agreement, but we're still in a position where none of the filings have been fixed. Payments haven't been made on the tentative consent agreement that we reached. So I told Mr. Mans I'm pulling the consent agreement. We'll set this for a preliminary hearing. We then discussed our options on whether they need to appear, whether they're going to contest this. And that's when we agreed. We crafted an order waiving the preliminary hearing and stipulating that there's reasonable grounds. There's 12 counts total that are listed. Again, the original complaint was 6 violations. The additional allegations, I did have to in part amend two of the violations in the original complaint just because they were pre-DOI contributions. And when I did the original complaint, I was basing those charges on the information in the CCDRs. And then when I actually got the financial records, I learned that there were more pre-DOI contributions. I also added, and this is in the commissioner's packet, the signed order that Mr. Mans and I had signed. But in that order, there's 12 violations. And there's a stipulation to reasonable grounds between Mr. Mans and I on all violations.
I went through and compared all of this, to the complaint and whatnot, and I see this again. If you want to use something as a template, I like how this is actually phrased, in this order. So to the extent that we have other ones, I just want to let y'all know that I think that this language at the very beginning is the appropriate language to have. I do believe that commission, however, needs to take some form of affirmative action, on this. And so I think that we're going to have to, someone is going to have to move to accept and approve this. And then I think that, I'm going to need to, I don't have a line on this one to sign, but I think that I'm going to have to sign this in particular because it's stated as an order as opposed to just some type of, agreement between the parties or something to that effect.
And that was, again, Mr. Knittel was referring to something Mr. Lane had passed to him, and I got it. And my thought was obviously we would have a stipulation to reasonable grounds. The board would find reasonable grounds, and then I would present the order to you after the hearing. But if
I may interject, and that's what had been done previously. Yeah, there was a separate order that indicated that there was a waiver that we provided to the chair.
So I don't know why I just can't, say, accepted and approved on such and such date, just sign this.
And
Mr. Armati,
and I would think that would be okay if you just signed it. I obviously didn't put, room for your signature, or in the alternative.
I don't either. That's what I'll plan to do.
Okay, very good.
I'll just go ahead and make a motion. I make a motion to accept and approve the order waiving preliminary hearing and stipulating to reasonable grounds as is presented to us today. Do I have a second?
Second.
Got a motion and a second. Any discussion?
So we do not have to read all these up.
I don't think so, because
to.
yeah, again, and I'll read this into the record. It says that prior to a preliminary hearing, Mr. Mark, through counsel, waives his right to a preliminary hearing, and this is the important part, I think, and stipulates that there are reasonable grounds to believe that the respondent violated the Campaign Finance Act in the following particulars, and it includes all 12 allegations that are in the complaints that were issued against him.
Yes, sir.
Okay.
And I think that document would be part of the record. So reading it into the record, we could do that, and I'm happy to do that. If
I don't see the need to do that.
I agree.
So again, we have a motion and a second. Any further discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. Any opposed? All right, that motion's carried. I'm sorry that I skipped over that, Mr. Baywalks.
No problem, sir.
All right, now, Mr. Canetta, we're going to move to the consent orders, item 4 under the agenda. All right, I'm going to recall the case, item A 24-0064-C in the matter of Clarence and Glenn Cook.
Thank you. This is A 24-0064-C. The office in this particular matter was for the Georgia General Assembly, House District 180. Mr. Cook lost in the primary. There was one violation in this case. He failed to provide sufficient detail regarding his campaign expenditures in violation of 21-534. The penalty in this case was a $125 late fee. And I'll indicate to the commissioners that Mr. Cook had all of his documents, but was missing some information on some of the individual expenditures that he made. And he corrected that by filing an amended CCDR. This was not a large money campaign. He mostly loaned money to himself. Essentially, he didn't provide the address of a campaign consultant. He didn't itemize some recipients of reimbursements. It was corrected on an amended January 31st, 2024 CCDR.
Okay, I think you just answered this and I just want you to repeat it so I can make a note. What is the insufficient detail?
The insufficient detail was he didn't provide essentially the address of a campaign consultant, and he didn't itemize some end recipients of reimbursements.
I don't really know how to do this necessarily. How is this different? Again, just as a hypothetical, how's this different from a respondent that fails to disclose the amounts and sources of contributions and expenditures?
It's essentially
Legally, it's the same concept.
Doesn't it
All right.
fall under technical defect though?
I don't think not.
Addresses.
I think end recipients is not a technical deal. I think you're not disclosing
The address.
everything.
I think the address could be a technical because I think he had the name, but he didn't provide all the information that was required.
So if we're reaching these consent orders for a particular amount of money due to insufficient detail, are the penalties consistent for that? Or are some details, worse than others such that the fine is higher?
Yes. Think back to the Coomer case. That's refusing to disclose end recipients. That's very different than this though, right? I think factually you have to look at it.
Was it different? He didn't.
But he's not talking about legality. He's talking about penalty.
I understand, but how's it different?
Because he wasn't disclosing that he was going to a family vacation in Hawaii. That's different than I said Amex and it really went to the consultant down the line.
But I mean, I think what the chairman's point is, speaking for him, is that if you're missing an end recipient, you're missing an end recipient.
Yeah.
Now, is the severity bigger because you're doing something personal? That's a different thing. But this individual is missing recipients.
But that's what I thought the question was, is the penalty consistent? And I think the answer is no. It depends on the facts of the particular violation, right?
Well, that wasn't
Okay.
what my question is, we have a case right here where we're saying that there was insufficient detail provided. If we have another case where we're saying there's insufficient detail provided, there is no difference in that legally. But I'm trying to figure out if we are consistently, fining folks for those. And again, what I'm hearing now is it all depends on the facts.
I think to a degree, yeah.
Okay. I mean, again, we've got another one of these again to approve. I'm not going to make reference to that specific case right now, but it looks like the allegations are the same. It's insufficient detail. And I'm sitting here looking at this consent order that's for, what is it, $125. I got another one here that, the fine's $1,000. So, that is a significant difference.
You're looking at this one.
Yeah.
That's one where we've removed that from the agenda. Two, I can tell you factually that is a different case. You're talking.
Oh, that is one that we removed.
We've removed that.
Well, now we just.
And Mr. Chairman, if we had presented that, when we get into the facts of that, you'll see it's not the same.
Well,
There are market differences.
okay,
factually.
let me say this, and I've been a little confused on some of these consent orders. I don't believe they're actually sometimes giving us enough information on. I mean, it's very general on what you guys are seeing. So somebody who looks at the consent orders is not going to be able to tell how they're different.
I agree with that. I think that if there's some exercise of discretion when we're talking about something like, sufficient or insufficient detail, I think that we need to have those facts in the consent order to show down the road, even for precedent purposes or whatnot, what the facts are that warrant $125 fine versus facts that warrant $1,000 fine. Does that make sense?
Yes.
I think that we need to put that in there. Because, if you tell me insufficient detail, I'm going right after this consent order from today and say, look, here's the precedent, it's $125.
I will commit to the commissioners that the new staff of attorneys will do that.
Okay.
This, we had some prior attorneys that were involved in some of these that are no longer with us.
I understand.
New set of attorneys will do that.
And I'm not blaming anyone. I'm not,
But I acknowledge you have a good point. So,
I mean, especially when you've got two on the same calendar. I understand. But, you know, it's a significant difference to me, especially if you're not, you know, paying that, you know, out of campaign funds, you know, to some of these folks won't have those funds to use to pay these, right?
Yeah.
Okay.
Let me change this one. It's 2020.
Okay. All right. So we're still doing all these as a one vote,
Yeah.
right?
yes.
Picture.
So, position.
I'm going to call item B 25-0023-C in the matter of Carlotta Harrell.
In that case, Ms. Harrell was the Henry County Board of Commissioners. She's the current chairwoman. There were 2 violations. She failed to timely file October 25th and December 31st, 2024 CCDRs. Those were election year CCDRs. Penalty in that case is $250 in late fees. There is some with her. Sorry, I'm looking at my notes here. She sent documentation regarding some health matters that she had around the time of the missing reports to the staff attorney. And so that is the resolution that was come up with there. She has since completed this. She had, she was in the hospital essentially. Okay. For a period of time. I just didn't want to get into details of her medical.
Sure. Okay, I'll call item C. It's case number 25-0010-C in the matter of Derek Mallow and Friends of Derek Mallow.
That office was state senator, second district, current office holder. There are 6 violations. Mr. Mallow failed to file 5 CCDRs in the 2024 election year. That would be April, June, September, October, and December. And there was 1 non-election year CCDR January 2025. And he failed to file timely PFDS covering calendar year 2022. So that would have been a filing that was due in 2023. The penalty in that case that was agreed upon was $875 in late fees and $125 civil penalty for a total of $1,000. And he did provide all the requested bank and campaign account documents to the staff.
He did or did not?
He did.
Oh, okay. I got a question about this one though. Well, if I'm looking at the bottom of the page, the last sentence that runs over to the top of the second page.
We're talking about Mr. Malley, right?
Correct.
Okay.
It says respondent mistakenly relied on information contained on the commission's website, which showed he was in compliance as far as his personal financial disclosures. Tell me what was going on there.
I think this gets into what we were talking about earlier, how there's confusion between 2023, like the 2024 PFDS covering the 2023 calendar year. And so on the financial disclosure portal on the website, you can toggle between the years. So if you're mistaken about what report covers what, if you, example, think 2022 covers 2022, you may go to 2022 and, oh, it's there. Not recognizing that covered the 2021 calendar year. Does that make sense?
Well, so the information on the state website isn't wrong.
No, I think that's accurate. I don't
The
think,
individuals are confused.
yes, I think that would be a more accurate way to phrase that.
I was going with the website was wrong. Because that's crappy.
Decent default.
Okay, anything further on that, Mr. Canoe?
No, sir.
Okay, item D. Case number 24-0102C in the matter of John Redlinger.
Yes, in that case, the office was Sheriff of Henry County during the 2024 election cycle. He was a candidate. He was not successful. There were 7 violations, failed to timely file a DOI, and failed to file CCDRs for April, June, September, October, December of 2024, and also failed to timely file the PFDS, which would cover calendar year 2023. Mr. Redlinger also provided all of his requested documents to the commission. So very cooperative with the investigation. His penalty that was agreed upon was $875 in late fees and a $125 civil penalty for a total of $1,000.
I'll call item E, case number 25-009-C in the matter of Colton Moore and Moore for Georgia.
Yes, that the office is State Senator, 53rd District, current office holder. There were 3 violations in this matter. Mr. Moore failed to timely file CCDR for January 31, 2025, and failed to timely file PFDS, which would have covered years 2022 and 2023. The penalty that was agreed upon was $375 in late fees and a $125 civil penalty, with a total penalty of $500. Mr. Moore did provide all the requested bank and campaign account documents.
Looks like your last case is item F,
Yes,
case number 25-0011-C in the matter of Freddie Powell Sims.
yes. That office is Ms. Sims is the state senator, 12th district. She's the current office holder. There were 3 violations in that case. She failed to timely file 2 CCDRs, being the December 31st, 2024 and the January 31st, 2025 CCDR. She failed to file a PFDS covering calendar year 2023. The penalty in that case was agreed upon as 2 late fees of $125 each and a civil penalty of $125 for a total of $375. I do want to indicate to the commission that upon receipt of the complaint, Senator Sims immediately contacted staff, explained the situation, took full responsibility. She actually came over to our office and furnished all the requested documentation, and even provided, a check and said, just let her know what the penalty is going to be. She was extremely cooperative in this matter.
Okay, those are all of yours now, Mr. Knittel, right?
Yes.
All right, before you start, Mr. Baywall, we're going to take a quick break. Yes, sir. So we're going to be in recess for 10 to 15 minutes or so. Is that okay?
Yes, sir.
This will also give you additional time, Mr. Knittel, to speak with Ms. Tsai.
Thank you.
All right, we're in recess. All right, I'm going to call this meeting back to order. It looks like we are on item H under consent orders. Mr. Baywall, these are yours. First case I'll call is case number 24-0108C in the matter of Anna McCoy.
Ms. McCoy, she's currently on the Billerica City Council, and this case was a case that we tentatively had an agreement for a resolution on our January 2025 board meeting on that calendar. We didn't get it assigned or executed a consent agreement, so we pushed this to March. I lost all contact with Ms. McCoy in March 2025 at that board meeting. We did have a preliminary hearing. The board did find reasonable grounds on all violations listed in the complaint. Before we sent the case up to the AG's office, Ms. McCoy did contact me, and she asked if she would still be able to resolve the case. We did deviate from the original consent agreement based on the fact that we went to a preliminary hearing and she lost contact with us. She did apologize. She works as an accountant, and she just said that this was the busy season of her business and that was the reason why. But not a great excuse, but at any venture, she expressed that she would prefer to resolve this by consent agreement. We renegotiated a consent agreement, and part of that was that before this board meeting, she pay the penalty in full, which she has done. But she agreed that there were two violations. There was one violation of 21-534M for failure to terminate her 2021 campaign for office. And there was one violation of 21-5-50A, and that was failing to timely file her calendar year 2021 PFDS. That was something that she filed pre-complaint. She was 12 days late, but when we did address the complaint, I added that allegation in there. The penalty we agreed upon was that she paid $250 in late fees, a $500 civil penalty, for a total penalty of $750. And again, that has been paid in full.
Okay, item I, case number 24-0038C in the matter of Georgia Whistleblowers PAC.
Yes. This case, the entity Georgia Whistleblowers PAC registered with the Secretary of State as a PAC. In actuality, they were functioning as an independent committee, not a PAC. This is a case that Mr. Cusack took out, and it was relatively early in the organization's existence. The gentleman representing the entity responded to Mr. Cusack. He provided the financial records for what turned out to be an independent committee. He ended up dissolving the entity pretty quickly after this complaint was filed. But he did provide records. He had an expenditure for a website that was used to oppose a candidate for office in Georgia in the 2024 election. The amount in controversy here was under $200 that was spent by this independent committee for this website. There was some other information they put out, but a lot of that was on free channels. So it was not a campaign contribution or expenditure. It was just simply free speech. But essentially, that was the issue in this complaint. The gentleman representing the entity, he agreed that there was one violation of 21-5-34E, and that was failing to register as an independent committee. He agreed to pay a $250 civil penalty, and that has been paid in full.
Item J, case number 25-0016C in the matter of Therese Johnson Morgan.
Ms. Johnson Morgan currently serves on the Gwinnett County Board of Education. This was a third-party complaint that came in, and Ms. Johnson Morgan had a previous third-party complaint that was an active case, and the previous case is the subject of an administrative dismissal only because I merged both violations in both cases into this consent agreement. But Ms. Johnson Morgan acknowledged two violations of the Campaign Finance Act. Violations of 21-5-50A. She failed to timely file her calendar year 2021 PFDS and calendar year 2023 PFDS. She received $250 late fees, $250 civil penalty, total penalty of $500, and she has also paid in full.
Item K, case number 25-0018C, the matter of Rachel Stone.
Ms. Stone currently serves on the Gwinnett County Board of Education. This was a third-party complaint that we received. The violation was violation of 21-5-50A. She failed to timely file her calendar year 2023 PFDS. Ms. Stone immediately contacted us. She filed the missing PFDS. All her other filings were in order. She was very cooperative and very quick to get this matter resolved. She agreed to pay $125 late fee, $125 civil penalty, total penalty of $250 for the violation.
Item L, case number 25-0034-C in the matter of Marion Leon Jones.
Mr. Jones is the sitting coroner in Macon Bibb, and he agreed that there were three total violations. There were two violations of OCGA 21-5-50A for failing to file calendar years 2021 and 2023 PFDSs. One of those was filed pre-complaint, but he still had an outstanding late fee. He also had a violation of 21-5-34M for failing to terminate his campaign account. He agreed upon three late fees totaling $375, $125 civil penalty, total penalty of $500.
So he filed 2022?
The filing year 2020, I believe he did. I'm not exactly sure which one of the ones was filed, but I'm pretty sure one of them was filed, but just filed late. But I could be mistaken with that.
Item M, case number 24-0119-C in the matter of Natalie Hall.
Ms. Hall is here today. I did let her know that she wanted to address the board or if they had any questions. She's available for that, but I believe she doesn't necessarily want to make a statement, but she is here today observing. She was a former commissioner in Fulton County, and she agreed that she had 4 violations of 21-5-50A. She failed to file calendar years 2020, 2021, 2022, and 2023 PFDSs. She also agreed on 10 CCDR violations of OCGA 21-5-34. She agreed upon a penalty of $1,750 in late fees, $3,250 in civil penalties for a total penalty of $5,000. I will say too that Ms. Hall's already been making payments on this amount.
Yeah. There's a,
I was just doing
the vice chair just noticed on the order
With his keen eye.
I'm sorry.
that the $3,250 has got an extra set of double zeros.
Yes, that was in there.
Yeah, I characterize that as like a scrivener's error.
Yeah.
And I think that we can just mark that off before I
Yeah.
sign it. It'll be okay. Yes, sir. Thank you, Mr. Thompson.
You're welcome.
Sure. Last item is going to be item N. It's case number 25-0029-C in the matter of Chelsea Thompson.
Ms. Thompson is a registered lobbyist in our system. She lobbies on behalf of Frontline Policy. Her lobbying target is the General Assembly. She agreed that she had 3 violations of the Campaign Finance Act, 21-5-73B. She failed to timely file disclosure for January 15th, February 1st, and February 15th. And she agreed upon a penalty of $825 in late fees.
I do have one question before I ask if anyone's present to make any statements with regard to any of the ones that you presented or Mr. Canetto. In the McCoy matter,
Yes, sir.
was she still within that 30-day grace period when y'all decided to resolve this, or was the case actually docketed at OSA?
We were still within that 30-day period.
Okay.
On this last one, Thompson, in the matter of Thompson, why is the late fees $275 each when all the other ones were $125?
So separate to the lobbyist code, they have a different fee structure. And the base level is a $275.
Never seen a late lobbyist fee before because there's people that know how to do it. So
I think the safe bet is if the legislature is going to enact penalties against themselves, they'll double it for lobbyists,
I
right?
got you. Fair enough.
Is anyone present for any of the cases called on the consent order that would like to make a statement? All right, hearing none. Do we have a motion with regard to the consent orders?
Mr. Chairman, first, I would like to pull one of the consent orders out and take it separately, which would be C 25-0010-C in the matter of Derek Mallow.
Okay, so you want to pull that to address it separately?
Yes, please.
All right. Well, let's go ahead. Do I have a motion with regard to all consent orders with the exception of what's listed as G, which is not on the calendar, and then with the exception of C, the Derek Mallow matter?
So moved.
Is that a motion to approve them?
Yes.
All right, we got a motion. Is there a second?
Second.
Got a motion and a second. Any discussion? All in favor say aye.
Aye.
Any opposed? Hearing none, the motion carries. Commissioner Thompson, do you have a separate motion with regard to 25-0010-C?
Yeah, my problem with this is the sentence right before the conclusions of law. When else up on on page 1.
The last sentence on page 1 that runs over to page 2?
Yes.
Okay.
First of all, I don't think that's factual because we did call. So there wasn't, he mistakenly made a mistake. And that's the sentence that I don't believe should be in there, where we're actually giving him some kind of, we're taking some responsibility.
Yeah, can someone, I asked about that particular sentence. Mr. Knittel, can you, again, I tend to agree the way that it's worded. It sounds like the website showed that he was in compliance. Is that
The way it's worded.
the way it's worded is what I'm asking?
Yeah, and that's not accurate factually.
Okay.
So I'm gonna make a motion to
Table it.
renegotiate this.
Yeah.
And get it re-signed.
Yeah.
Removing that sentence.
All right. Okay, I got a motion. Is there oh, sorry.
I'll make a motion, a second, but what's the impact of what you're doing?
Well, just a sentence that's basically saying that the commission's website was wrong. And it wasn't wrong. You just didn't read it correctly. I don't think our agency, unless we are at fault somewhere, should take responsibility in any way.
So there's no different impact. You're correcting that language.
Well, we have to take it off.
I understand.
Renegotiate it.
I got it.
Yeah, again, the way the sentence is phrased is that it sounds like that the website showed he was in compliance when he wasn't in compliance, and that's the reason for the violation. All right, so I got a motion. Do I have a second?
You do.
I got a motion and a second. Any further discussion? Hearing none, I'll call the question. All in favor, say aye.
Aye.
Any opposed? All right, so Mr. Knittel, that one is going to be, it's tabled. We don't have a consent order. And so you guys need to work on that. And if you can't get a consent order, then again, by the next meeting, have a preliminary hearing on it.
Yes.
Okay. All right. That takes care of everything under the consent orders. I'm going to move back to item 3 on the agenda. It's item A, case number 24-0098-C. This is in the matter of Nicole Messiah. Mr. Knittel, do you have anything to report now on that case?
Yes, I do. So Ms. Messiah has provided me with financial documents that I will need more than this morning to review. But more importantly, she's going to get those CCDRs filed that are missing. Then I'll review that in conjunction with the documents that she provided me. And we'd like to ask to continue this to September meeting.
Okay. Again, based on your representation and what I expected, how I expected that to move forward, I'll go ahead and make a motion that we continue that case until it's ready to be
Yeah,
presented.
I don't want to say September.
Actually,
Yes, we talked about geographic
Yeah,
location.
we don't want her to have to drive to Savannah.
So, all right.
Well, but if you reach a consent, she'll be.
Right. And it's more of a placeholder just so we keep moving forward. But we're working on it. And I feel like it'll get resolved.
I guess I'm going to restate my motion to some degree. I'm just going to make it, I make a motion that we continue that case. Do I have a second?
Second.
I got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. Any opposed? Okay, Ms. Messiah, that case is going to be continued. We'd like you to work hard with Mr. Knittel to go ahead and see if we can't get that case resolved.
We will. We've even realized that there was a suite number on the address. So, yeah, that speak to it.
Again, thank you very much. Thank you for coming.
Thank you.
Yep. All right. We're going to move to number 5 on the agenda. These are compliance orders. Going to call case 25-0010 read 3-C in the matter of Macon Bibb County Industrial Authority. Mr. Amati, I understand that you're actually presenting that. Is that right?
Yes, sir. So this is a case, and to start, state law prohibits a government agency from spending any resources, giving any money to any type of campaign or ballot initiative. So this is a case that involves the Macon Bibb Industrial Authority giving $50,000 in violation of that statute to a ballot initiative in favor of a SPLOST referendum. Now, and to be clear, the ballot committee disclosed the contribution it received from the industrial authority. So it was there to be seen. Upon investigating and looking into this case, what we came to understand is that the industrial authority typically gives $50,000, something like that, every cycle to an educational initiative, which is permissible. They're allowed to give for educational purposes. They're not allowed to give for advocacy purposes on SPLOST. In the past, the industrial authority had the same group, the same 501c4 charity they gave that money to. I don't know what happened to that charity, ceased to exist. So they selected this new committee and donated $50,000 for what they believed to be educational purposes. And in reviewing records, we saw email correspondence, invoices that specifically discussed, we're giving you this money to educate the public on SPLOST. Nowhere in there was any agreement about advocacy. Unbeknownst to the Macon Bibb Industrial Authority, some of those funds were later used by the ballot initiative to advocate for SPLOST. A couple things I will point out, because we're doing something a little abnormal here. We haven't done this in a few years, which is a compliance order where we say, A, the law was broken, but B, given the facts related to the industrial authority, it's really not appropriate to monetarily penalize them when through counsel they received advice. The documentation with the ballot initiative did not appear to be a ballot initiative, but appeared to be educational. The funds they gave actually were not tax funds. Macon Bibb Industrial Authority is one of the few that by state law is allowed to raise private funds. So no tax dollars were spent here. By all accounts, it appears that the industrial authority believed the money they were giving was for educational, informational purposes regarding the SPLOST, and they did not come to learn until after the fact that some of that money was used improperly for advocacy.
1 second, Commissioner, because I've made my opinion known.
Sure.
With regard to these compliance orders. First, why is this called a compliance order when you just said that the act was violated? It's not in compliance with anything.
We could have a conversation about handling these differently, but this is how we've handled cases in the past where they're making sort of proactive efforts to come to compliance with the law and ensure they're not violating it, but not being penalized the monetary amount.
Okay, and again, I just have some other questions. What's the legal authority behind a compliance order? Where does the Campaign Finance Act say that we can handle this via a compliance order? Does that exist?
I don't know if it's in rule or not, though.
Okay. Now, my next question, and I'll be done
I
with.
think it is, but
I'll be done with this. I'm not sure that I agree still with this concept, in and of itself, but how is this really different than an administrative dismissal?
I think an administrative dismissal appears to be us saying, yes, the violation occurred, but we don't care. We're not even going to recognize it occurred. We're dismissing the case. And I think that's bad precedent. Yeah, it's in rule.
Okay. I think that's
A compliance order is saying that we recognize the law was violated, unlike a dismissal, which says we either don't recognize or don't care. I think that's a bad message to send. I think a compliance order where we say, yes, the law was violated. Yeah. Yes, the law was violated, but because of these extenuating circumstances, we're taking a different approach, which you will see there's plenty of factual information in this compliance order justifying why we're doing what we're doing.
So an administrative dismissal is one where we can't find the violation.
Exactly.
A compliance order is where we find the violation, but there are circumstances such that there shouldn't be a fine.
Correct.
All right. Vice Chair?
Yes. Well, I don't understand because you said that the law was violated. And then you turned around and you said that the specific section that you quoted as being violated, these were private funds and there was no state or there was no tax funds.
Correct.
How can it be both?
Because state law in the 30.2 section about public agencies does not designate tax dollar funds. It just says no agency shall give any money, period.
And no one shall accept.
And no one shall accept.
So is Big Show or Go Big or whatever the other people's name is, why aren't they?
They have an active case separate from this, and it will be, it's not, we're not quite to the point where the consent is signed. I do expect that to happen, but there will be a monetary
And this will be
penalty
addressed there.
there. That will be addressed there, correct. I should have led with there is a corresponding case.
You should have.
Yeah.
Agreed.
Okay, that all makes much more sense. So, well, with respect to this compliance order, is there a motion? I'll make a motion that we accept the compliance order as presented. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye.
Aye.
Any opposed? All right, that motion carries as well. We're going to move to the next item, which is item 6 on the agenda. This is the administrative dismissals that were just discussed. Is there any necessary presentation with respect to these? Probably no. Vice Chair.
Yes. I would like to remove D 25-008-C in the matter of Ben Burnett. I have reviewed this, asked the staff for their documentation, and I think that this one is important to be presented to the commission so the commission can look at all the facts here in administrative dismissal. All the facts aren't there. And looking at the disclosure reports and looking at the administrative dismissal, I just think it would be better for the commission to review it.
We have discussed if the commission chooses to remove it, we can bring it in the form of a motion to dismiss at the next hearing where there can be more questions and answers provided, sort of in that vein. But that's obviously a y'all decision.
You know, these administrative dismissals don't require any action.
They require action to really unwind it.
Right.
So we need to make a motion to.
Yeah.
See, but now again, this is an entirely different process from what we've done, because if everyone agrees with the administrative dismissals, there's no action taken. I mean, should we be taking some action when we get to these to say, okay, we approve all of these? Because if we're not taking that action to approve them, how can we take that action to remove?
I think what the motion Commissioner Thompson should have made was a motion to invalidate the administrative.
Wait a minute, does it need a motion? Can't we just pull an item from the agenda?
No, because the dismissals in particular become, accepted upon my signature. So to undismiss, he's basically wanting to undismiss it.
I'm not sure I understand that process, but is there a motion with respect to item 6 on the calendar or on the agenda? Sorry.
I make a motion to remove 6D 25-0008-C from the administrative dismissals.
Second, but I just disagree. I think we ought to be able to remove any item from an agenda.
Okay.
But I'll support it to hear the facts.
Thank you.
I got a motion and a second. Any discussion? Hearing none, all in favor, I'll call the question. All in favor, say aye.
Aye.
Any opposed? Opposed. All right, we're going to move on to item number 7. This is the report of the executive director, Mr. Amati.
Thank you, Mr. Chairman. Got 3 items I'll discuss today. The legislative recap is listed as A, but I'm going to do that last as that'll just take the longest. And I think it's important we talk about all the things that we changed this year. From a budget recap report, a little bit of back and forth with the House and Senate, but ultimately we came to an agreement of $150,000 budget increase to the agency's budget. Primarily for purposes of increased IT costs with the new system we'll be rolling out near the end of the year. And that brings the commission's budget somewhere in the neighborhood of $3.4 million a year. Good work with our legislative partners there and appreciate their support. We do have some staff changes, if you probably already noticed. Beginning with us Monday will be a new staff attorney, Kristen Judd, who I believe you all met earlier. We're very excited to have Kristen join us. She's coming to us from the Cobb DA's office, but I think several of us know her from previous jobs that she held, and I think she's going to be an asset to the Ethics Commission. Mr. Baywall has finally, after years of persistent requests, agreed to come on full time, and so Mr. Baywall will be off the contract and on the full government dole. So we'll expect to see more consent orders from Mr. Baywall, and most notably, he negotiated a term in his hourly contract that he only had X number of prelims a year. And so now that's out the window, and I think we'll be seeing more of those from him as well. We also have an intern for the summer. Mr. Chairman, bite your tongue. He is at the University of Alabama. But we're giving him a shot anyways. We're excited to have Isaac Bialco working with us, finance, accounting major. So I think he's going to be able to help us and hopefully learn something. Last, I will go into what was, I don't want to say the largest piece of legislation we've passed in the last 7 years, but certainly could be. I mean, it was significant. Vice Chairman was helpful in his thoughts on some of these issues. I'm just going to go through this section by section. This is SB 199 as signed by the governor. Currently, and this will go into effect January 1 of 2026. But currently, the Ethics Commission does not accept ethics complaints within 30 days of an election, whether it's a primary, general, special. The idea being most of those complaints are political footballs lobbed at the last minute that they don't have time to reply to, that are just trying to muddy the water. We have extended that period from 30 to 60 days. We're hoping that makes this less of a football. And in the event that it does come in, say 61 days, there's a better chance we might have time to sift through it and dismiss it if that's appropriate. A big part of the next 10 or so
Is that
pages.
something that was happening a lot, that we were getting those complaints within 30 days?
I think there could be a fair argument to be made that yes, and targeted. You would see similar filers making a lot of these allegations.
Okay.
A large section of this bill, in sort of the middle of it, beginning January 1 of 2027. So we've created a sunset provision, and I'll explain why. But beginning January 1 of 2027, all local filers will be coming back to the state. This is long overdue. I believe this Commissioner Wise may remember back in 2013 when this went the other direction. There have been a lot of issues with that. And frankly, GMA and ACCG and Gavrio all supported our efforts this year at the Gold Dome. So there was agreement that this needed to happen. Now, we're sunsetting it a year and a half to give us time sort of to get the new system up and running, to give us a year and a half to sort of start educating the locals, bringing them into the fold without it happening overnight, and also to get past this municipal election coming up this year. So I think leading into the 2027 municipals is the perfect time.
Will you have to staff up then?
I'm going to be asking for additional staff.
Yeah.
I don't know how significant the staffing up request will be on the legal side because, the lawyers already handle the locals. But from a training, from an education, from some of our clerks, I do think that's going to take more manpower. And that'll be a big sort of objective for us in the next legislative session.
You don't think that the number of those, sort of what, Commissioner Wise said, that the number of those local violations aren't going to increase since we're seeing it on the front end now?
Yeah, because when we brought it over to the Ethics Commission in the past, it's because we had all the information in the database where we could just run algorithms.
Right,
Yeah.
right.
But it also streamlines it. You don't have to deal with the local officials or try to find the paper or whatever. So yes and no, right? This technology will be there. So
The only reason I said that is I felt like even from the staff, even from one side of the staff perspective, it's going to have to increase the number of lawyers.
I think that's realistic. I don't want to commit to how much I'm going to be asking the General Assembly till we sort of get our feet in there and sort of get an idea. But whether Blake Tiller and Matt Hatchett know it or not, I'm going to be asking them for more money. So that will be coming. Some other changes we have beginning January 1 of 26. So everything is effective January 1 of 26 with the exception of the locals. That's not till 27. So beginning next year, we are completely overhauling the filing schedule dates. Right now, In non-election years, you have 2 reports. In election years, you have 6. What months in a non-election year reports are different depending what type of office you hold. They ping pong back and forth. It can get confusing. The same is true of financial disclosure reports. Some years it's by July 1. Some years it's within 7 days of qualifying, or maybe 15 days, depending on the office. We are streamlining this. I don't care moving forward if you're a city councilman, county commissioner, the governor, anyone in between. You will have the same 4 campaign disclosure dates every year. You will have the same 1 financial disclosure date every year. These were all targeted to make sure they come out the information before elections so that there's so the financial disclosure report obviously has to come out before the primary, or voters won't necessarily know the information they may want to know. So to accomplish that, I couldn't think of a better date than April Fool's Day for elected officials to disclose their financial records to the public. The campaign disclosure dates will be January 31st, April 30th, which again is before that May primary, July 31st and October 20th, so that it'll be before that November general. A lot of support with this effort at the General Assembly with the locals. I think this is going to be a big improvement as well. Another change we made, and it was a good legislative change. There is going to be more work on the commission side with some rules we probably need to promulgate. But we have passed legislation that moves the PAC filing schedule to this quarterly report, and has said political action committees need to maintain their own separate bank accounts, as candidates already have to do. There are some questions, and I'm not going to try to get too deep in the weeds yet, but there are some questions about difference between corporate entities, whether they're a PAC, whether or not they're not, when they have to register with the commission, because another change we made is once you cross that $25,000 threshold as a PAC, you will now keep filing until you wind it down. Whereas in the past, you terminate at the end of every year. So you may be a PAC 1 year and not hit the threshold the next, and the next year you are again. And in the gap, we sort of miss where some of that money goes. So this is a good change, but it will take some more effort. I think we'll probably have a proposed rule in September for the board, for the commission's consideration. But that was something we've been working a few years on. Similar to, so the financial disclosure, April 1st for everyone, with one exception. Municipals don't qualify till August. So they're the one exception where they're financial September 1st. That was higher we had to make it the end. As part of this package, when local candidates at the county and municipal level qualify, they'll now have to sign an affirmation that they're going to take mandated trainings under state law with either the counties or cities. This was sort of a rider request from ACCG and GMA that we agreed to include. Doesn't really put much work on us. It's just codified within our type. We also edited the disclosure. We changed the disclosure reports for the lobbyists. Very similar. They have 2 reports 1 month, 1 report another. The days are different depending on whether they're in session or out of session. This is another area where we've regimented. We've said you got 1 report, it's this day every month. We also, I think this is going to be a big improvement for transparency. In the at current law until the new year, if you register as a lobbyist, you may have to register as 5 different levels of lobbyists. You're a lobbyist at the state level, but also state vendors, but also state agencies, and also locals, and also the state transportation board. And so you file 5 different reports on the same day each time it's due. Well, if I want to know what lobbyist X is doing, I may have to skip between 5 different reports. It's all going on 1 piece of paper now. So I think this is something the lobbying community like. I think from a public trust and informational standpoint, it's going to be a big improvement there. One of the last changes we made relates specifically financial disclosure reports, but only for statewide partisan candidates. Those individuals, as Commissioner Wise knows, have to file an enhanced financial disclosure report in their election year. And under current law, they have to, and this is actually changed, Commissioner, since you left the PSC, but under current law now, they have to disclose their income each of the prior 5 years and the sources of where that income came from. And a complaint we got was, I'm not going to know the exact dollar amount I made at this corporation for 3 years. I've got accountants trying to figure that out. So what we've done is we've said, no longer do you tell us the exact amount. We're going to create ranges. I made to this company somewhere between $50,000 and $100,000 this year. And I think that is just a reasonable compromise and, ensures that they're not inadvertently violating the law when they fill these reports out.
And it's kind of based on the federal law.
It's almost directly tied to the federal FEC code. The last significant change we made, beginning January 1 of 2026, when an official or a candidate files financial disclosures with us, we will be redacting their home addresses from public view. We've seen a lot of doxing. We've seen, sadly, I spoke about this at Biennial in Athens last year and indicated to the General Assembly this is something I was going to take on. They were very pleased, but it hit in the AJC a few days later that there was a doxing at a congresswoman's house where an officer was killed in response. I mean, I know people who this has happened to in public office. This is happening more and more. We try hard to balance the First Amendment freedom of information, issues with common sense public safety. Notably, public officials will still tell us where they live. They will still be telling us their residences, property they own. So it's not like this is now information no one knows, but we're going to sort of redact that from public view. And that is the substance of SB 199. Couple years of work went into this bill, and we're very happy with the changes.
Is that last change that you just mentioned, is it now listed as an exception or something under the Open Records Act?
So no, because there are other agencies. So the Judicial Council, and we've been working with the Judicial Council on this. The Judicial Council put together a Judicial Security Committee, and this commission, I have an appointee to the ad hoc sort of advisory board. They have identified 3 different layers of residential information being public. Tier 1 involves the Ethics Commission and the Secretary of State's office. Those are the 2 highest profile, most accessible, most in-depth. The information is redacted from public view with us. So if someone opened records that information from us, they could not get it. But there are other agencies where that information is still out there and subject to open records. I know that's still an issue they're going to be pursuing moving forward, but we can only do what we can do, right?
Okay, thank you very much, Mr. Amati. We'll move to item 8 on the agenda. Ms. Young, the report of the Attorney General's office.
Come over here because I can't see all of y'all from my seat. I don't have a whole lot to report to y'all this time. We have our one active litigation matter that is pending a motion to dismiss in federal district court. This is the leadership committee challenge that has been brought by the Libertarian and Green Party.
Could you speak up, please?
Sure. There's a challenge to the leadership committee statute that allows candidates for governor and lieutenant governor to form leadership committees. And it has been challenged by the Libertarian and Green parties because that statute does not allow political bodies to form leadership committees, only political parties. Judge Cohen in district court has typically been receptive to challenges to that statute when it sets up a non-level playing field between candidates or between local parties and bodies. However, we have asked that he dismiss this particular case, given that the parties themselves are neither subject to the leadership committee statute, because political parties cannot form leadership committees, only candidates can. And it is unclear as yet whether either or both of these parties will be fielding candidates for governor or lieutenant governor. Typically, the Libertarian Party has in the past. The Green Party never has fielded a candidate for governor or lieutenant governor, at least as far back as I've been able to tell. That would, if successful, still leave the possibility that after they have their nominating commission, they do the, undertake steps necessary to qualify their candidates. Could lead to a later challenge that would be viable by those candidates that's down the road. If Judge Cohen decides to let the parties sort of act in the stead for their candidates, then we may get an order sometime between now and the next meeting. I would expect Judge Cohen is not ruling particularly quickly in this case, but I would expect for sure that between now and September, we will probably see an order on our motion. There may be some limited discovery that we need to do. And follow up in terms of what, if any, action the court is going to take in terms of whether or not Libertarian or Green Party candidates will either be allowed to form these types of committees or find any relief from the typical campaign contributions of 21,541, which is what they are seeking to do. We will let y'all know as soon as an order drops on that either way. We've currently got, I've got 2 full-time attorneys and our governor's honors fellow working on enforcement cases and able to solve a number of them without taking them to OSA. And I have a number of them also geared up to go to OSA, including some in South Florida that will require some travels, just so you know, for budgeting purposes. Some of those may end up having a little bit more expense than some of our other cases, but we've been working with Steve on those. Those have been moving along. Keep that while we have a bit of a lull in our litigation effort. So that's all we've got for now.
Any questions for Ms. Young?
Thanks.
All right, we'll move to item 9 on the agenda, public comment. Is anyone here for public comment? We did, okay.
Good morning, Commissioners. I'll be brief. Tommy Travis, South of Capitol Coalition. I have come before you guys before, and this is like my 3rd meeting. I've come to respect highly what you guys do, and I respect that you guys uphold the letter of the law regardless. So I just wanted to thank you on behalf of the Southwest DeKalb citizens and the organization that I represent. I want to thank you for the work that you do and continue to represent us in an impartial way and upholding the letter of the law, regardless of the rhetoric that's thrown back and forth. So thank you.
Thank you very much, Mr. Travis.
Thank you.
Anyone else? Hearing none, we'll go ahead and move to item number 10. Make a motion that we adjourn. Do I have a second? Second. Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? Motion carries.